SoundCartel.
The heady time of setting up a business is in fact the best time to consider what if it all falls apart. So before you and your partners sign on the dotted line, make sure you've planned for the worst case scenario. From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. So, you've decided to set up a business with your mates or family members. It's exciting and you have a lot of goodwill between you. What happens though if things take a turn for the worse and you have a falling out? Or there's disagreement about where the business is heading? If you haven't planned for potential disputes from the outset, you could all find yourselves in a lot of hurt down the track, both legally and financially. That's the warning from Lionel Green, principal at Meltzer Green Lawyers, who's helped many businesses over the years resolve internal company disputes. So what are some of the more common disputes between partners or directors? Lionel Green's talking to Chris Ashmore.
The majority of these sort of disputes occur when there's two shareholders/directors. Invariably they are friends which have decided to go into business, or in a minority of cases it's family members. And where you have two people and over a period of time they decide that they don't necessarily agree on the major things affecting the business, and so a dispute arises. Now, most of the disputes are all about money at the end of the day, but a lot of disputes are really where the company is going, what direction it's taking, or if the company is about to or has ceased trading, who is to receive the assets of that company. And a number of examples that I have just by way of introduction is we had two chaps who had been lifelong friends and they wanted to go in different directions in business. So they decided that the venture that they were involved in would cease, but a dispute arose as to how the assets were to be divided. They'd been negotiating for about 6 to 12 months and getting nowhere. And in the end, we were just able to put a proposal to the other side, which was agreeable, and therefore the dispute was resolved without the need to litigate. The other side of that coin is where a dispute occurs where the only option is, after a long period of time, to litigate. We had a company who was controlled by second and third generation family members, and the principals couldn't decide what direction the development of its property assets should take. In the end, there was litigation which lasted for close on 2 years, but in the end, the parties resolved the matter after about 4 or 5 different mediations, and assets were divided and the parties could then go on their way. The common theme running through all of those is that often you need a third party to negotiate rather than the parties or the company's accountant, which is known to both sides, trying to negotiate a settlement. So you need really external intervention.
Well, when setting up a business structure or even restructuring a current business, what mechanisms should partners and directors keep in mind to deal with disputes?
Well, the best thing that parties can do when they're setting up a company is to have a shareholders agreement. Now, that agreement can set forth the rights and entitlements of the parties, and also can have a provision that if there is a dispute, the mechanism for resolving that dispute can be detailed in the agreement, such as appointing an arbitrator to resolve an issue in dispute, or someone that is known to both parties and the parties have confidence in the business acumen of that third party. That would shortcut a lot of disputes which exist between the companies. Clearly, every little thing which becomes in dispute would not be put to an arbitrator, but we're talking about the major issues here, which have significant financial consequences.
Well, what are the options available to resolve internal disputes?
I've just referred to shareholder agreements. That is the most productive and cheapest form of resolving disputes. Another option is the appointment of a company administrator under the provisions of the Corporations Act. Now, the problem associated with that is that both directors have to agree to the appointment of a company administrator. You can't have one director saying, yes, let's put the company into administration, and the other one refusing to. That's a deadlock, which then means you can't go into administration. Another example is clearly to negotiate, which I've just covered. But when the parties are entrenched in their position, often the best and quickest form of resolution is to place the company into liquidation under what's called the just and equitable basis. Now, that necessitates an application being made to court, but the process should only take 5-6 weeks from issuing an application to resolution of the matter and a liquidator being appointed. Once a liquidator is appointed, he is then responsible for the control of the assets and conduct of the company, and he makes the decisions rather than the directors and shareholders. Now, there's also another possible claim that a director or shareholder could have, and that is in the scenario where there is a minority shareholder. If they feel that the decisions of the majority are not in their best interests and they're being oppressed, then there is a proceedings under the Corporations Act whereby a minority shareholder can bring a claim in Supreme Court and let the court decide what should be done with the company. Often that involves a lot of work in preparation for a case of that nature, and invariably it will be strongly opposed by the majority shareholder. But it does have a number of options available to the court to make orders for the company going forward.
If all avenues have been exhausted and still there's no resolution to a dispute, Lionel, is there an option of last resort?
Really, the two options where you've been unable to negotiate or agreement reached is either to litigate or to make an application to the court that the company be wound up on a just and equitable basis. They're really the only two last resort options available.
That was Principal at Meltzer Green Lawyers, Lionel Green. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow at BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel.